Hello, and welcome to today's episode of Gavels and Gowns, a Williams Mullen education law podcast, where we explore topics that are important to leaders of institutions of primary, secondary, and higher education. I'm one of your co-hosts, Hal Johnson, and I'm the chair of the education practice here at Williams Mullen and a partner in our litigation section in Richmond. I am joined, as always, by my co-host, Micah Schwartz, who's a partner in our labor, employment, and immigration section, and he's based out of our Charlottesville office. Micah, how you doing?
Doing okay, Hal. How are you doing today?
Doing well. We are joined today by a very special guest who also happens to be a new colleague of ours, and that's Stephanie Karn. Stephanie recently joined Williams Mullen about 3 or 4 months ago. She's a partner in our labor, employment, and immigration section, and she's also seated here in Richmond, where I am. And it gives us a lot of pleasure to welcome Stephanie to the podcast and to our firm. So, Stephanie, how are you?
I'm doing great, Hal. Thank you so much for having me here. I'm glad to be here with both of you. Just to give you a quick background on me, I've been in private practice since 1995, all of it here in Richmond. Although, as you said, I only joined Williams Mullen in the fall of 2023. My typical workday is split between employment issues, management side, and higher education issues, including Title IX. In the Title IX arena, I have provided training on Title IX, drafted Title IX policies and procedures, served as a neutral investigator, and even undergone training of my own as a Title IX coordinator. In other words, I am very happy to talk Title IX and all of its nuances with the two of you today.
Absolutely. And that's exactly what we're here to talk about. I think one reason why we're doing this podcast right now, and hopefully folks will find it to be very timely, unless you've been living under a rock in the world of higher education, you're probably aware that there are some anticipated changes coming to Title IX from the Biden administration. And there's nobody who's more able to address some of those changes and has better background in Title IX than Stephanie. So, Stephanie, thank you for being here with us to talk about some of that. And the goal here today, again, is to touch on some high-level points about anticipated changes when the changes to the regulations come down. And that leads, I guess, to the first question. When is this going to happen?
Great question, but I'm going to take you back one step further first. As a quick refresher, I think it's important to reiterate kind of the primary purposes of Title IX and actually what Title IX says. It says no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And as you stated already, Title IX, which applies to elementary, secondary, and post-secondary institutions, does each of the following. 1, it prohibits limitations on participation based on sex. 2, it focuses on equal funding of men's and women's athletics. And we're going to, I'm sure, have another podcast coming up soon on that topic when the Biden administration issues another set of regulations. 3rd, it prohibits discrimination based on pregnancy, nursing, or parental status. A little bit more of that later too. And 4, sets forth detailed requirements, including grievance procedures for addressing sexual harassment, sexual assault, stalking, domestic violence, and dating violence. Each of those terms, you should be listening to them as being capitalized because they're all defined terms under Title IX. But in response to your question, Hal, we're anticipating that the new regulations, which seek to expand on several of these existing purposes, will be issued in late spring with an anticipated effective date around mid-August, very similar to the timing with the 2020 regulations. The Department of Education sent its final rule to the White House Office of Information and Regulatory Affairs, or OIRA, for those of you who love the acronyms, for review on February 2nd, 2024. That office can take up to 90 days to review the rule and even make changes, although they seem unlikely. So in other words, not within 30 days, more likely 60 to 90, and we'll have the typical couple months turnaround time to put everything in effect.
Got it.
Well, thanks, Stephanie, for covering the background on Title IX and also the when that Hal asked. My question is the what. What are we expecting the changes to be in the next couple of weeks? I should say at the outset, for those of us who've practiced in this area, the 2020 regulations seem very recent, and I think a lot of our educational institutions have just gotten adjusted to working under those regulations. So it's disheartening to think that there might be some changes coming around the corner. How big do you expect those changes to be?
Well, first, as background, I don't think anyone listening to this should be surprised that if we get another change in administration after this one, we're going to see changes in the regulations again. I think that is going to take us through for the next 10 to 12 years, but I anticipate the changes will get smaller and smaller, sort of a pendulum swing in the other direction with Biden, and we'll work our way back to the middle. But in terms of substantive changes that we're expecting now, where do we start? I'm going to hit on, as you said, and as Hal said at the outset, some of the bigger ones. The Department of Education refers to several of these as major provisions, but we're going to hit the highlights. First, the scope of Title IX is going to be expanding in a number of different ways. It's going to provide additional protections from sex-based discrimination and harassment, including discrimination based on sex stereotypes, sex characteristics, pregnancy or related conditions. Yes, they're in there already, but Biden administration wants to expand the scope and the recognition of them, sexual orientation and gender identity. None of this should come as a surprise given the executive orders that have been issued by the Biden administration, especially in the areas of sexual orientation and gender identity. The second change is going to be under the definition of actionable harassment that creates a hostile environment. It's going to be changing from conduct that is so severe, pervasive, and objectively offensive, a threshold that was higher than it had needed to be proven, certainly under Obama's administration, to conduct that is, quote, sufficiently severe or pervasive, unquote, and that carries both a subjective and an objective perspective. End result there is on the actionable harassment is going to be a much lower threshold that needs to be met to establish responsibility under a Title IX policy with the new regulations. Next, Title IX coverage will also expand to include off-campus conduct that creates or contributes to a hostile environment in a school's education program or activity. Currently, activities that fall under the umbrella of a Title IX policy need to occur in the United States, for example. The new regulations are going to recognize that the policy will cover conduct that occurs outside of the United States. Classic example, and one that I've actually investigated in the past, is a sexual assault that occurs at a study abroad program in another country, but involving two students who are students of the institution that is stateside. The alternative or additional category now is conduct that occurs outside of the school's education program or activity, but again, has some tie-in to the educational program or activity, even if it's just jurisdiction over the parties. So an example of that would be a sexual assault that is alleged to have occurred off campus, in off-campus housing that is not tied to the school. It's the respondent's apartment, but the respondent and the complainant are still on campus, and the complainant alleges that the activity or alleged conduct is interfering with their ability to participate in the educational program or activity. And finally, still hitting the highlights of what some of these changes are, the status of a complainant will change. At the time they make a complainant no longer needs to be participating in or attempting to participate in an educational program or activity. A Title IX complainant can file a complaint about sex discrimination they experienced, even if they chose to leave the school's education program or activity, either as a result of that discrimination or for other reasons. And this one is interesting because there has been an uptick in respondents questioning the status of a complainant when a complaint is made under the current regulations. Complainant is participating in an activity and the incident occurs and they are slated to graduate a week later, and respondent is arguing that they should not be a complainant because they are no longer participating. Under the current regs, at the time they filed the formal complaint, if they are, it's good. Under the change, it doesn't really matter. It's going to stay with us even if they leave before they file the complaint. Next, the new regulations are anticipated to expand the list of personnel who must notify the Title IX coordinator of conduct that may constitute sex discrimination under Title IX. Right now, we're working in a world of those who get actual knowledge or actual notice and having to be high-level administrators who can effectuate change. No longer going to be the case. It is no longer just those persons who have the authority to take corrective action, but certainly for student-involved incidents, any administrative leader on campus, any teacher, or any advisor in the school's educational program or activity. This will still exclude confidential employees. Schools will still be able to designate persons in their health center, counseling center, and the like as confidential employees, but even they will now be expected to provide the Title IX coordinator's contact information and reporting information to any person who comes to them with a description of event that could trigger Title IX coverage. Another change, this one is a distinct change, is in the area of supportive measures. A school will now expressly be permitted to utilize temporary measures that burden a respondent, and specifically says a respondent, so long as they are not punitive or disciplinary. The purpose of doing so is to preserve, among other things, a party's access to the educational program or activity and or protect the safety of the complainant or even the safety on campus. So one example of this would be a alleged sexual assault. We're going through the process, respondent has been notified, respondent and complainant may be in the same track, the same department, set to graduate. And if deemed appropriate by the Title IX coordinator as a supportive measure to allow the complainant to feel safe continuing to attend classes, they could notify the respondent, you will be allowed to participate, but you may only participate remotely. We're going to set you up with Zoom. We're going to say, stay in your apartment, go home and participate that way. Not saying this does not happen under current regulations, but this is now explicitly going to be codified in the regulations. Finally, and again, I'm only talking highlights. We could go for 2 more hours on all the minutia of the proposed changes, but the new regulations are not going to mandate a live hearing as part of the grievance procedures. So where the 2020 regulations now said, guess what? You're having a live hearing. The 2024 regulations, because we are now back to a different administration, are removing that absolute and stating that schools may designate the Title IX coordinator or an investigator as the decision maker, and thereby forego a formal hearing, at least at the initial determination stage, depending on how they set up their process. Regardless of the format used, whether you still go with a live formal hearing or a single investigator model, the new regulations require the decision maker to assess the credibility of the parties and the witnesses, especially when credibility is in dispute and relevant. And you would do that in the single investigator model through live meetings with each of the parties and the witnesses. In the formal hearing, you're obviously going to be able to do it there. This last item about the change to the formal hearing requirement, I would put an asterisk by that. Absent any last minute changes in this final stage of the process, I do expect we're going to see legal action the first time a party learns that their case is now not automatically going to be at a live hearing, when for the last 4 years it's been required to be that way. But we're not there yet. So just put a star by that one.
So in other words, it sounds like, Stephanie, not much is going to change at all. Is that fair to say?
On levels, yes. I mean, in some ways I think a lot of Title IX coordinators are going to say, hey, in some ways we're doing the extra protections. Other people are going to go, I have no idea what you're talking about. What do I do?
And I'm obviously kidding. There's a mouthful there, and there's a lot that we could discuss in much greater detail than we have time for today. But I think the takeaways for college is, it sounds like in universities and Title IX coordinators, is that the scope of what is covered by Title IX is expanding, it's broadening, and some of the, I guess, procedural steps that were put into play under the Trump regs may be getting rolled back a little bit when it comes to hearings and things like that. With all that said, and without getting into the details of anticipated language in the regs and that sort of thing, how would you distill this down into maybe 2 or 3 practical tips for our friends out there who handle Title IX cases on a regular basis? What should they do between now and the time these regs actually come down to get ready for some of these changes?
Absolutely. Get your ducks in a row. Get the key players lined up that you will need to effectuate changes with your policy, with your training. So move quickly, as quickly as you can, to make sure that your Title IX policies and procedures are revised to comply with the new regulations. The sooner that's done, the more time you will have to train everyone. And I mean everyone. You're all used to doing the training of the students, maybe separate training for student athletes, separate training for RAs, but this is now part and parcel of orientation, certainly, and the start of each school year. And you've done it with some of your employees, you're going to have to do it with everybody. Shorthand answer, if they set foot on your campus and you have some control over them, you're going to train them. Make sure that your essential players, and now we're talking about Title IX coordinators, deputy Title IX coordinators, investigators, advisors, hearing board personnel, if you're using them, read through your revised policy once you have it, and not just the sections that apply to them. They need to be familiar with the ins and outs, because there's going to be, relation back and crossover. And it also helps to make things easier the first time they're called in to serve as an advisor or serve as an investigator. Line up legal counsel to assist in either drafting your revised policies and procedures or at least the final review. Of course, we here, the three of us on here and our group here, can help with all of that. But, certainly if it's not us, make sure it's somebody. You want that second set of eyes on there no matter what, and they need to be trained and really ready to go in this area. And additionally, and I mentioned this at the beginning, be aware there's going to be, and has started already, an increased emphasis on protections for pregnancy and related conditions, lactation, and parental status. The new regulations are designed to clarify and highlight these prohibitions. And, speaking for myself, I've already been called in a couple of times to advise in connection with pregnant students on campus, and especially pregnant athletes. And it sometimes surprises people to know that there is a whole detailed set of rules in connection with pregnant student athletes, for example, and that you cannot tell them that they can't play simply because they're pregnant. And you cannot tell them that they shouldn't go to class, and a few other things. So just another thing to take away from as being part of these new regulations that may be a surprise for people.
Well, thanks, Stephanie, for trying to distill all of that into a few practical tips. I did want to ask you one more question before we wrap up here. And it concerns timing, because you alluded earlier to the fact that there's a good likelihood that these regulations are going to get challenged in court. And again, we're used to this now with these more political regulations. They tend to be challenged pretty quickly. So for universities and other educational institutions that are trying to adapt to the new regulations, what would be your advice if they get a case, let's say next week, and then the week after that, the new regulations are issued? Would you suggest that they kind of put things on hold to see how litigation develops, or instead should we expect to put these regulations into place immediately? And kind of going along with that, do we need to expect that they'll have retroactive effect cases that happened just a couple of weeks ago?
To give the classic pithy lawyer answer, maybe to all of them. But excellent questions. And part of this is going to be a moving day in and day out. But in the meantime, our people need to not just simply put everything on hold. You don't want to get dinged on the opposite end for not moving proactively and quickly as you're supposed to do under Title IX regulations. I will say the last time OCR declared that its new Title IX regulations did not apply retroactively, August of 2020, Federal District Court in New York promptly and quickly disagreed. This was in response to a motion for temporary injunction filed by a respondent who was trying to understand why he did not automatically get the new protections of a live hearing and a few other things that were in the new regulations, simply because the complaint had been filed prior to August of 2020 and had not yet gone through the process in full. The end result from that ruling, and the federal court agreed, hey, look, if a hearing has been deemed essential, it should be essential for everybody going forward. And I'm going to completely ignore the retroactive statement of OCR. So the end result was most schools applied the new 2020 regulations, and especially that very new requirement of a live hearing, to any complaint that had not yet been concluded. So my recommendation right now, with all the usual caveats of it'll be interesting to see what maybe the preamble is and what guidance we get from OCR's blog the day or two after they issue these regulations, would be for schools to take an expansive view and focus on providing the most equitable process available. So that could mean retaining the live hearing component, even if the new regulations say one is optional, or expanding the jurisdiction of Title IX to now say that an alleged sexual assault that occurred in a study abroad program, for example, will be addressed through Title IX and not another student conduct process. The best advice I can give, though, is to have your legal counsel on speed dial if you are facing a timing issue this fall, and let us answer that question for you as quickly as we can.
Thanks, Stephanie. Pithy Lawyers is actually one of the titles we considered for this podcast, but decided to opt for Gavels and Gowns. And I think that's probably a good place to wrap up this episode of Gavels and Gowns. Thanks for all of that information, Stephanie. And thanks to all of our listeners for joining. One more practice tip, as Stephanie mentioned, one of the obligations under the new Title IX regulations will be heightened training obligations. We want to help you all by getting training materials ready. So we're working on that now. And once the new regulations drop, we're able to help you with your training obligations. So check back in with us if that interests you. If you have other questions about the work that we do or suggestions for future podcasts, then please reach out to us for those reasons too. You can also visit our education page at williamsmullen.com. And there you'll find out more about what we do as an education team and the kinds of legal services we provide to educational institutions. And finally, be sure to subscribe to this podcast series to be notified when our next episode posts. Thank you, Stephanie, for joining us. And Stephanie and Hal, hope you both have a good day.
Thanks, Mike.
Thanks, guys.
Bye.